Distinguished delegates, Excellencies, sorry, as you can see, our lawyers have been in hot debate. In this case, I would make a ruling from the chair, and it can, of course, be challenged from the floor, but I would suggest in the interest of us moving on with this afternoon's proceedings that you don't object from the floor, but that is, of course, your privilege. As the affected country, I would like to give the distinguished permanent representative of Syria the opportunity to make his statement from the podium. Thereafter, we'll revert to the normal procedure of making statements from the floor, from our chairs. Does anybody object to that ruling? I see no objection, so decided. Would you please take your place on the podium, Ambassador? And the 10-minute restriction, of course, is being observed from all speakers before the vote.
Thank you, Mr. President. Thank you for your being a true legal counsel that knows how to decide on legal matters with impartiality and objectivity. Before I start my statement, I would like to congratulate Liechtenstein on its unholy alliance with the state of Qatar in presenting this draft resolution. Once again, Mr. President, few days after a similar erroneous Canadian move, the General Assembly finds itself vis-à-vis another movement which is devoid of transparency, impartiality, and legality. This is a result of the practices of the Liechtenstein delegation that launched this initiative, which violates paragraph 7 of Article 2 of the Charter, which states, "Nothing contained in the present Charter shall authorize the UN to intervene in matters which are essentially within the domestic jurisdiction of any state, or shall require the members to submit such matters to settlement under the present Charter." End of the quotation. This is the matter which the legal counsels should have buckled down on studying it, instead of trying to prevent me from addressing the General Assembly from this rostrum. The contents of the draft resolution presented to you today proves considerable hypocrisy and enormous gap between the theory and the practice with regard to respecting the Charter and the sovereignty of member states. Permit me to make some observations that refute this draft resolution and expose the intentions of its co-sponsors. First, I would like to refer first to paragraph 1 of Article 12 of the Charter, which states, and I quote, "While the Security Council is exercising in respect of any dispute or situation the functions assigned to it in the present Charter, the General Assembly shall not make any recommendation with regard to that dispute or situation unless the Security Council so requests." End of quotation. In the Syrian case, as you will know, dear colleagues, the Security Council is still seized with its responsibilities, as you will know. Morning of the day before yesterday, it adopted Resolution 2328. This proves that the delegation of Liechtenstein, as well as that of Canada, violate the principles and goals of the Charter. The General Assembly does not have the jurisdiction to establish such mechanisms mentioned by my colleague of Liechtenstein. This is entrusted with the Security Council only and not by Liechtenstein in alliance, in league with Qatar. The establishment of such mechanism, if the General Assembly is to do this, requires an authorization from the Secretary General after an exclusive consent by the concerned state, that is the government of Syria. All these matters have not been respected by the co-sponsors, nor did the legal councils say anything about it. Establishment of such a mechanism is a flagrant interference in the internal affairs of a UN member state. It undermines the legal jurisdiction and legal proceedings within the purview of its national authorities and organs. Establishing such a mechanism at this decisive stage undermines the national reconciliation efforts undertaken by my government, adopted and agreed to by large categories of my people, and they have been effective in many areas. More important than that, the establishment of such a mechanism is a direct threat to the vistas of political solution in Syria. All relevant security resolutions stated that this should be a Syrian solution-led process, not with the Liechtenstein in league with Qatar. Consequently, this draft resolution reflects the intent of some co-sponsors to politicize such mechanism and to render it as a means of political reprisal and the perpetuation of conflict in my country, Syria. Third, the draft resolution is based on contentious and deeply controversial language inside this international organization. The co-sponsors try to embroil the member states in dangerous legal precedents that will become rules on which states will build their attempts to legitimize their interference in the internal affairs of other states. Talking about concepts and terminology by way of talking about responsibility for protection or non-national and putative jurisdictions or other international and regional courts reflect the conduct of some member states in formulating and presenting draft resolutions under mendacious humanitarian coverage, incorporating and furtive language, ambiguous terminology, bombastic expressions that lend themselves to more than one interpretation, to be applied in a manner that makes it inimical to the declared humanitarian wishes in service of the well-known historic agenda of these states that paid no heed to human rights, the welfare of people, or sovereignty of states. This agenda is represented in trying to legitimate the external interference and to topple legitimate governments by military force, destroy the resources of peoples, steal their wealth, disjointing and disintegrating these peoples in sectarianly and religiously under the coverage of the UN resolutions. The Charter entrusted the United Nations to protect the rule of law, the territorial integrity of these countries. Examples are well known, particularly what is happening in some African and Latin states as well as in Iraq and Libya. Fourth, the co-sponsors completely disignore talking about terrorism to which my country is subjected. There is no even an allusion or reference to terrorism or the practices of terrorist armed groups in Syria. This is well expected since the co-sponsors of terrorism in Syria, Turkey, Saudi Arabia, and Qatar are among the co-sponsors of this draft resolution. Those who deserve to be held accountable in Syria are those states that created the armed terrorist groups, supported and financed them, open to them oil and money to buy weapons, conscript terrorists, and to spread Takfiri ideologies, and they opened their orders to secure the arrival of FTFs into Syria from more than 100 states. Permit me to say here that it is enough for the permanent delegation of Liechtenstein policies of hypocrisies to adopt and to participate in the presentation of this initiative with other states that bombard civilians in Yemen and cut the necks of the citizens as they do in Daesh does in Syria and Lebanon. Result of such hypocrisy is the arrival of the ideology of terrorism to some European capitals as a result of the condoning by EU governments and to be in league with the magnates of oil and those custodians of terrorism, contrary to what they claim as protecting humanitarian and human values and civilizations. We would like to advise on this occasion those who joined the co-sponsors to read the book that was issued recently by the two French journalists, Georges Melbourneau and Christian Chenou, our very dear princes, which cites documented stories about financial corruption with the princes of Qatar and Saudi Arabia. The movement by the delegation of Liechtenstein are shrouded in suspicions. In less than 1 week, it hastened to present this draft resolution without any consultation with my country being the concerned states. Then it requested informal consultations with specific states whose positions are well known against my countries. It put this draft resolution to voting in a surprising manner. Co-sponsors included a paragraph indicating that financing this machinery will be from contributions by member states, contrary to what the Liechtenstein said, that it will be from the regular budget of the United Nations. Paragraph OP5 states that financing the machinery will be from the budget and from external contributions. Then it will not be an independent machinery. لقد تجاوزنا.
I have 2 minutes, Mr.
Thank you.
I still have to. أثبتت
The experience inside this international organization proved that governments that finance such committees and mechanisms decide their directions and the outcome they come up with in advance. How is it possible that those who finance this machinery are co-sponsors of terrorism, particularly Qatar and Saudi Arabia and some European countries that export exclusive European terrorism to my country and to Iraq? In conclusion, Mr. President, I request that this draft resolution be put to the vote and call upon the member states that believe in the principles of the Charter and to vote against this draft resolution before the GA. Your voting, dear colleagues, against this draft resolution does not only feed into the national interest of Syria and its people that still suffer from terrorism. It is a victory for the remaining credibility of international legitimacy. It is a protection for all of you from the attempts of some states to channel UN resolutions to target national sovereignty of your states, targeting legitimate judiciary and legal institutions representing our countries and peoples. I would like to recall that my country will never vote against any member state in this international community except in line with the Charter and international law. Thank you, Mr. President.
And I thank the distinguished permanent representative of the Syrian Arab Republic.